This article is for trial lawyers. The first rule, there are no shortcuts to a successful trial. Second rule, preparation is everything. If you don't prepare or fail to prepare the right way, prepare to fail. Here are some techniques that I've learned over time. These apply to trials in both civil and criminal cases. As always, caveat emptor. Tip number 1. The human mind is hardwired to remember events in a certain way, in order of time. A chronology will show what occurred first, what occurred next. A simplified chronology is an essential tool. It will be invaluable to a trial judge. Prepare a 2-page chronology with 3 columns. The first column should set out the date or the time. The second column should say in one line what happened on that day or at that time. The last column should set out the exact location where the evidence of this event could be found. Second tip, prepare a draft closing speech long before the first day of the trial. I learned this from an English QC. When the client comes in to give instructions, after preparing a simple sound chronology, prepare your closing speech for the end of trial. You must first assume that all the evidence that you need is available and admissible. You must also assume that you would have adduced all needed relevant evidence. So at the end of the trial, what arguments will you put before the judge? So in the draft closing speech, insert all the elements of the causes of action or your cause of defense. Against each, raise the relevant evidence in your favor. Contradict the evidence against you. Ensure proper research is done on all necessary legal points, particularly those that trouble you. Attack your opponent's best evidence, then ask yourself these questions. Does this tell my client's story? Does this deal with all the legal issues that I have to surmount? Does it break down my client's factual and legal defenses? Where are my weak points? Then ask yourself some what-if questions. What if some essential evidence is not available? What should I now do? What if some evidence is missing? What should I do? Note them down. Write them out. That is your draft closing speech. Now that's different from a final closing speech. Even if a draft speech is a bit rough around the edges, it doesn't matter. You'll see at once where your vulnerabilities are, where your weak points are. In the UK, the lawyers call it the good facts versus bad facts analysis. Same thing here. It will have a particular effect on you long before the trial starts. It will be a helpful guide. It will focus your work. It will give you a battle plan. At the last minute, you won't panic. You won't risk writing an inadequate, ill thought out submission. It will also tell you where the deep issues of the case will come from. When the time comes to draft the issues in dispute, your mind would have attained a very high level of clarity, and this will be better than your opponents because you would have thought about all these issues over a long period of time, and your mind will create peaks and valleys and tell you which are the dangerous areas, which are the important areas, and so on. And you would have done it from the beginning. You'd have focused on it all through the trial. You know exactly where you're going. You know exactly how you have to deal with each point. You know where the booby traps are and what to do to avoid them. You would have mapped out your strategy on day one. Wouldn't that reduce your and your client's stress levels? Or are you going to go into the High Court like this? Oh my God, I don't know what he's going to do. Oh my God, what about that evidence? So don't wade into battle without a battle plan, because a battle it is. Tip number 3, make sure before you get into trial that your pleadings are complete and concise, or if they are not, amend them quickly. Pleadings are the backbone of your case. They must have 2 qualities. They must be 1, brief, and 2, as complete as possible. Complete does not mean 50 pages of meaningless drivel. The judge won't read it, he'll go to sleep. The moment the judge reads it, immediately he must grasp what you want in 1 minute. Judges don't like long pleadings. They hate last-minute amendment applications. So understand that you have to prove every point you put in. He who says something must prove it. He who asserts must prove. So why burden yourself with long pleadings? The longer your pleadings are, the longer evidence, the more evidence you have to plead. And then the longer the pleadings are, with delight and glee, your opponent will cross-examine your client and reduce him to powder and dust. So watch what you plead. Tip number 4. Ensure that pleadings disclose facts of main elements. So your pleadings must show what facts that are the main elements of the causes of action if you're a plaintiff, or a cause of defense if you're a defendant. Plead the facts, not the evidence. Understand this difference. I'll give you 2 examples. First example, suppose you act for a plaintiff. It's a claim for negligence. Your facts must correspond with the elements of the torts of negligence. You must plead in this order. You must first plead the facts that impose or show to the court that they impose a duty of care on the defendant. The second thing you must do is that there was a breach of those duties. The third thing that you must do is to show that there was loss, prejudice, or other damage suffered by your client. And then this is an element everybody misses, or almost everybody misses. You must show the causative element and connect the defendant's conduct and the loss. So you must say in your pleadings, but for the defendant's negligence, acts, or omissions, the plaintiff would not have been put to loss, prejudice, or injury. Second example, if you allege a breach of contract, plead the facts that show, number 1, the fact of agreement, number 2, its vital terms, and number 3, which terms have been breached, in what way, particularize the nature of the breach. And then you must say, what is the effect of the breach on the contract? Is it a mere breach of warranty? Or is it a repudiatory breach? Why? Because the kind of breach will control the consequences. Then you must detail what loss has been sustained. Be careful to remember, in common law jurisdiction, there are 2 types of losses. The first limb losses are those that naturally arose in the usual course of things. Plead that. If it's a second limb damages are sought, the Victoria Laundry sort of damages, then you must plead that the parties knew, number 1, when they made the contract, number 2, that the damages incurred were likely, number 3, the word is likely, to result from the consequences of the breach. Then number 4, plead the details of those. Some causes of action or defense require explicit pleadings, limitation, fraud, special damages, or in defamation cases, fact-comment, qualified privilege, or malice. These are all in the rules. Be mindful of those. Tip number 5. Prove fundamental facts to obtain pleaded relief. You are in a court because you're asking for a certain kind of relief, or you are arguing that your opponent is not entitled to the relief that he or she is asking. The first thing the judge will always look at is the prayers. She will ask herself, can I grant this relief this plaintiff is asking me? Do I have the jurisdiction? Okay, I may have the jurisdiction, but do I have the powers? At some point, while you're busy cross-examining everybody, trying to impress your client, she'll stop you and she'll ask you, do I have the power? Do you think, counsel, I have the jurisdiction? Be prepared to answer those questions. So after checking the relief in your pleadings, ask yourself what facts you need to prove and what the legal test is that you need to satisfy, and then what is it that you must do for the judge to give you what you want. Every prayer requires you to prove a basic structure. Ensure that for every relief, that basic structure is there in the body of the pleadings. Be meticulous about it. This is the reason why when I plead, I will first plead the relief and then put in the body of the pleadings the fact pattern for each. For example, if you seek for specific performance of a contract, don't you think you need to establish that, first of all, a contract exists, that your client is a party to that contract, that the other side has breached it by refusing to perform its terms, and that damages won't suffice? Or if you're asking for an appointment of an investigative auditor, what facts do you think needs to be shown? What are the investigative auditor's powers? Can he enter certain premises? Whose premises can he enter? Can he conduct a search? What can he cart away? Documents? Chattels? Having carted them away, can he keep them? When and how should he report his findings to the court? Have you checked the law in this area? How have the cases dealt with it? Give these points your full attention. They are the only ones that matter. Tip number 6. Ensure that you have a convincing, reasonable hypothesis. Your story must be real. All cases have a narrative. Each party has a story to tell. Will your story and the evidence fit? Is it believable? Is it reasonable? Is there a ring of truth to it? Or does it appear too fanciful, too full of details? If it is, your opponent will have a field day. The judge will be reluctant to wade in, and she won't believe you, and she will allow your client to commit seppuku. So prolixity breeds judicial doubt. The longer you are, the more the judge will disbelieve you. Tip number 7. Deny every allegation that your opponent throws at you in his pleadings. When specific allegations are made against your client, deny each one at a time and deny them specifically. Lord Denning once said, general denials don't work. It's not good enough for you to set out the details of your alternative hypothesis. You must specifically deny the allegations of your opponent. You must say the contents of paragraphs 9, 10 and 11 are denied. And Malaysian lawyers have this tendency, and the plaintiff is put to strict proof thereof. What does the word strict add to the sentence? The contents of paragraphs 9, 10 and 11 are denied. The contents of paragraphs 9, 10 and 11 are denied. So don't just breeze past paragraph 37 saying nothing. Say the contents of paragraph 37 are denied and the plaintiff is put to proof thereof. Tip number 8. A bad denial defense is disastrous. A bad denial defense is dangerous. Once your opponent has proven his case, no matter how weak it is, your bad denial will be as dead as a doornail. So, tip number 9, have an alternative hypothesis. Plead a defense hypothesis, a defense story. It must be reasonable, plausible, and it must be a correct or acceptable alternative to the plaintiff's narrative. Tip number 10, marshal all the evidence to support your alternative hypothesis. Evidence comes in the form of the testimony of witnesses, oral evidence, or documents. Your proven facts must be consistent with your hypothesis. Arrange it that way. Lead evidence in chief to strengthen it. Cross-examine to flesh it out. If you look at the trial chart, you'll find that for each element, you'll need a specific evidence and support. The judge will search for it anxiously. Help him. Prove those facts. Look for the originals of the documents. If you cannot find the originals, then you have to use the various methods of proving secondary evidence of the document. For that, go to tips 12, 13, 14, 17 and 18. I now move on to tip number 11. You need to get a helicopter view or aerial view of both sides' cases, and you do that by preparing a trial chart. Prabhkirat Singh wrote a book called Civil Trial Advocacy, a practical guide. It sets out a brilliant strategy for every trial lawyer. See how he has done it. I've amended his trial chart to suit my own purposes. Set out each cause of action, its elements, and the evidence supporting or opposing every element, the details of the documents, its maker, where the documents are, and the location of that document. You will see this in my text article in the website I describe below. Test every element, every cause of action or defense against the evidence. Examine the evidence. your witness testimonies, the documents to prove or challenge each of these elements. This will give you an excellent aerial view of your entire case, including how your opponent will attack your witnesses. Tip number 12, collect all documentary evidence and call the persons who signed them. We call them makers, long before trial. Find out who the maker of every document is. A maker is the person who wrote or received or signed the document. Can he be located? Will he be willing to come in as a witness? Don't assume they'd be delighted to attend the trial. Some people get cold feet. They hurry off on holidays one day before the trial, or they'll fly off to unknown places and remain incommunicado. If a witness is out of jurisdiction, how is his evidence to be made admissible? Decide whether such a person has to be compelled to attend by the issuance of a subpoena. These things you have to do months ahead of time. Because if he refuses, you have to apply for subpoena. They've got to get it heard. They've got to issue the documents. Tip number 13. If you can't obtain primary evidence of a document, arrange to produce those documents as secondary evidence. You've got to complete the process. What are those processes? You must think of these things long before the trial, months ahead of time. If the maker cannot be called as a witness, if he's dead, how do you intend to adduce that crucial document? If the original is not available, how can you produce its copy as a secondary evidence? Check out which sections of the Evidence Act needs to be invoked. Understand thoroughly how various sections, for example, in Malaysia, sections 56 to 114 of the Evidence Act work. Decide what steps need to be taken to bring the evidence in, to make it admissible. You may need to place advertisements in 3 different languages in 3 major newspapers. Or you may need to make repeated physical efforts to locate the maker. Do that. Take those steps meticulously, carefully, and bring them to the judge's attention very early. The judge would appreciate it, and the judge would appreciate the effort you took to make the impossible document admissible. Courts are busy. Trial judges don't like last-minute adjournments to bring in new witnesses. Tip number 14. If you've issued a subpoena to a witness, file and serve the subpoena on him months ahead of time. Sometimes case management falls at the last minute. Trial dates are given at the 11th hour. You cannot let this stop you from applying for numerous subpoenas ahead of time. If you want the witnesses to testify orally, immediately take out a subpoena ad testificandum, which means come and give oral evidence. If you need the witness to come to court carrying with him certain documents, specify in your subpoena and ask for a subpoena ducus tecum. Specify exactly what documents are needed and prove that point. This description must be clear and detailed. You cannot say bring all those documents in the years you are in control. The judge won't accept that. You can't take out a rolled up subpoena, one that is both for oral evidence and for documents. Tip number 15. Demand documents from your opponent very early. The procedure for notices to produce. It's entirely possible that some of your documents are in your opponent's possession. If so, ensure you serve on him the notices to produce. File them, serve them quickly. Take all the steps that are necessary under section 66 and other rules in the rules of court. This must be done months ahead of time. No point in panicking at the last minute. Did you know that you can force your opponent to disclose documents to you even before you file an action? It's called pre-action discovery. Go look for it. Do that if necessary. Now that's not all. You can also demand documents from non-parties through what is called a Norwich Pharmacal order, but that can only be done after you commence your proceedings. At trial, write out a 3-page opening speech. A few days before trial, send an opening speech to the judge and to your opponent. It mustn't exceed 3 pages. It must explain your hypothesis, the number of witnesses you wish to call, what they are expected to say, and what you intend to prove at the end of the trial. Tip number 17. Marshal evidence of quantum ahead of time. You need to prove that your client has sustained prejudice or damages, right? That requires not just evidence, but solid evidence. Sometimes it's a matter of calculation or a matter of analysis by some kind of expert? If so, look for an expert. Help him with all the relevant details. Divide the damages claimed into different heads. For each head of damages, ascertain who will prove the damages and what documents are necessary for that. Get those documents. Get the expert to write a report that will prove that such and such damages occurred. And tip number 18, if you're calling an expert, he has to qualify as an expert under the rules. So if you call expert witnesses, you must call clear evidence to demonstrate that the witness is in fact an expert. But a court can appoint an expert witness too. So understand the difference between different rules that deal with party-appointed experts and court-appointed experts. The difference is vast. The expert must be advised that its duty is to assist the court, not to support the one side or the other or the guy who paid the fees. That's not an expert. That's a one-sided witness. As such, the rules require the expert to declare certain facts on a formal document before he is appointed as an expert. Make sure this is done. All your opponent has to do is to state to your expert witness, under such and such rules of court, you are required to furnish a declaration, aren't you, that you're an expert? Can I confirm now that you've not done so? And that is the end of your expert evidence. Did you know that the court can order experts called by both parties to hold a discussion between themselves and ask them to identify, specify, and reach agreements on certain points? But the contents of that discussion cannot be discussed at trial unless the parties agree that it can. Any such agreement between the experts doesn't bind the parties. There's law to that effect. Tip number 19. Preserve evidence. It may take months, sometimes years for trials to start. In all that time, documents can go missing, your staff may misplace them, witnesses may disappear, or contrary documents may appear. So make a detailed chronological bundle of all those documents, and it is crucial that you ask your client to keep all the originals in a safe. Never hold original documents in your chambers. You get into trouble. Only keep the copies. Ask your client to produce the originals a few weeks before the trial. If he has lost them, it's not your fault. Examine how many witnesses you need to call. Investigate where they live, where they work, whether they can change their minds at the last minute. A witness may say one thing to you at first. Months later, just before trial, he might drastically change his story. There may be a good reason for it. He may have made a genuine error, or he may have forgotten some vital fact. Now, how are you going to ensure that the witnesses don't change the stories? Some witnesses get wise over time. It happens all the time. Someone may have gotten to them. Suddenly, they refuse to sign their witness statements. So to prevent a runaway witness, it's a good idea to make the witness sign a statutory declaration that the first time he gives you a testimony, all of it is true, there are no contradictory documents that he is aware of, and that he is happy to explain any contradiction in the future if it comes to his attention. Tip number 20. Attack your opponent's evidence on the first available opportunity. This is called the rule in Browne versus Dunn. You must put your hypothesis to your opponent's witness. The case of Browne and Dunn decided that if a party intends to contradict witness testimony, he must put his version of events to the other side witness during cross-examination. If you're for the plaintiff, don't wait for the defense case to attack your defense hypothesis. It will be too late. If the defendant has filed a bundle of documents, attack the defense documents at the examination in chief stage straight away. Assail the defense hypothesis from the word go. Put your hypothesis to each of your witnesses and his witnesses. Draw out evidence to support your side. Draw out evidence to contradict the other side. If you are the defense counsel, attack the plaintiff's hypothesis the moment you get on your feet. Take your own hypothesis and your documents and cast them in a nice, good golden light. By the time the plaintiff's case is over, the judge will have a clear idea of what the defense hypothesis is. You must do this in an organized, careful, chronological, and here are the important words, honest manner. Tip number 21. You had better understand what kind of witnesses you are facing. The truth is the truth. It will emerge from a witness the way he wants to say it. You cannot force him to see a truth that he doesn't want to remember or he doesn't remember. If he doesn't remember, help him bring it out. Different witnesses perceive the world in different ways. How their memory works depends on how they are wired inside their heads. Some may use descriptions of images. The door was brown. The other witnesses was using a black shirt. They are graphic witnesses. Some may recall events according to a chronological order. They will say, the 1st of January is my daughter's birthday. On the date this happened. By the time my son's birthday came on, the other thing happened. These are all time-sensitive witnesses. They are chronological witnesses. Some will associate a memory with the sound. These are sonic witnesses. He will say, I was on the 2nd floor of the building. I was looking down at the road. I heard a loud boom. A car had collided into a motorcycle. A man in a green shirt lay in a pool of blood. This guy is a sonic witness. He's also color sensitive. So some witnesses remember things by acting them out. They are the kinetic witnesses. Appreciate these differences. Tip number 22. A cross-examiner should have a roadmap to prove A, to prove B, to prove C, etc. Cross-examination is an art. Don't ramble. Keep it tight and short. Cross-examination questions should not exceed 7 to 12 words per question, mostly 7. It should mostly produce what is called a corralled answer, a yes or a no answer, unless you want a designated answer. I'll give you some example. By your words, you must fence in your witness. It's called corralling the witness. You cannot control the witness, then you are lost in the wilderness. Never ask an open-ended question. Never ask, so what do you think of the answer given by Mr. Mark Anthony? That is an invitation to places you don't want to go. It's a good idea to have a list of chapter headings for cross-examination. In each chapter, describe what objective you want to achieve. For example, your chapter on defense liability may say that show defendant was responsible for plaintiff's injury. Sole reason was gas explosion, no other cause. Then put it to the witnesses in simple, short words. Short sentences. Be polite. Get on his side. Bring down his natural inclination to distrust you. If you don't know the answer to a question, please don't ask it. So how do you think the tank exploded is an invitation to dance around in the woods in total darkness? Contrast that with this kind of question. Don't you think it was all the defendant's fault that the plaintiff was injured? It is still dangerously open-ended. Contrast those two questions with the following. Now, John is the name of the plaintiff. So you could ask, for example, the tank exploded on the 23rd of January 2017 at 8:35 p.m., didn't it? He will say, yes. The defendant company owned the gas tank? Yes. It operated the gas tank? Yes. Did John's duties require him to work near the tank? Yes. All the time? Yes. John was the only one working near the tank when it exploded? Yes. You're a qualified petroleum engineer, aren't you? Yes. Is it not true that too much nitrogen was being pumped into the tank at that time? Yes. Just before the explosion, the tank's pressure had exceeded the safety limit? Yes. That was the only reason the tank exploded? Yes. The force of explosion tore off John's foot, didn't it? I'm not so sure. He's dithering. So go on to areas familiar to him. John's injuries are consistent with the gas explosion, aren't they? Yes. There was no other reason other than the explosion for John's injury, was there? I'm not sure. He's being defensive. He's saying, I'm not sure. But you'd expect that, wouldn't you? So you ask him like this. Now, 5 minutes before the explosion, you had given him instructions? Yes. You had directed him to open the pressure valves? Yes. And then you hurried off to answer a phone call? Yes. After the explosion, you rushed to John? Yes. You were the first to reach him, weren't you? Yes. Why did you rush to him? This is an open-ended question but you have put him in a fence and he can only answer in a limited way. He will say, John appeared to be in a bad way. In fact, he was lying 30 meters from the tank, wasn't he? Yes. In a mass of blood? Yes. And he was missing a leg? Yes. It was all the defendant company's fault, wasn't it? I disagree. He's too quick off the mark, but you press on. That the defendant lost his leg? I don't know. What and who do you think the trial judge is going to believe? You or the witness? Draw out the truth. Lead the witness 1 millimeter at a time. Don't hurry. Know when to slow down. And remember, the judge is writing. Speak only when the judge's pen stops moving. Then let the witness step over the cliff. Cajole the witness. Don't try to make him look stupid. He will resist you with everything he has. Where would that leave you? Tip number 23. Understand the difference between documents placed in parts A, B and C. Part A documents are admissible. Their contents will be accepted as being true. Part B documents are admissible, but their contents are challenged, disputed. Part C documents are neither admissible nor accepted, period. Tip number 24. Don't take silly objections. The court will not forgive you. There is a pernicious practice that has grown at the bar. Unfortunately, I see this also in international arbitration. Counsel sometimes insists that his opponent places documents in part C of a bundle. This forces his opponent to get hold of the original document, forces him to bring the formal witnesses to court to mark the documents. Judges don't like that. It creates unnecessary delays. It creates a negative impression about you and your client, and the judge is beginning to think that your client is escaping his duty and that you, as counsel, and your client are opposed to the truth, and that you are not an honorable person. Tip number 25. Understand the rule in Sakako Takao. When your opponent adduces evidence on a point, attack it. If you let it go by, the rule in Sakako Takao will kick in. The trial judge then has a duty to accept your opponent's version as being true, unless the evidence is inherently improbable. Why do you want to go there? Attack the evidence. Tip number 26. Do everything you can to make the trial judge's life as easy as possible. Make the trial judge happy by intense preparation. Cut down your examination chief. Use your time economically, and the judge will love you for it. It will make all your work in later cases so much easier. The judge will say, this guy is here, it's very easy, he's organized, I'm sure I can finish the trial in 3 days. And you ask him anything, he'll give you. Think of the things the appeal court may look out for. Establish those points at trial. If your client loses his case, and if you appeal, the appellate judges are sure to ask you these questions. Question number 1. Do you think this point is an important one, Mr. So-and-so? Yes, my lords. Did you put it to the witnesses during cross-examination? Gone. What was their response? I'm not sure, my lord. I didn't ask. So where is this? So if you tell the judges, yeah, I did. So where is it? Did you bring it to the trial judge's attention? Where did you do it? Show it to us. What did the trial judge say about this in her grounds of judgment? So keep an eye on what you need to establish at the trial court so that you can satisfy the curiosity of an appellate tribunal. Tip number 28. Embed leave questions even at the trial stage. These are called appeal bullets and hair triggers. This is a precious technique. You know that you're going to get into trouble sooner or later. You put those questions of law and embed them in the trial. It took me a long time to understand this or to apply it correctly. It's called leaving appeal bullets lying around with hair triggers. Let your opponent or the judge step on them. Draft a series of questions of law that satisfy the principles in the Terengganu Forest Product case. At the trial court, adduce evidence in support of each of these questions of law. Argue on those questions of law. Put them to the trial judge. At the appeal stage, show that the trial judge had stepped on one of the hair triggers and fell into a serious misdirection, or he had caused a serious non-direction by not doing something he ought to have done, thereby had occasioned a miscarriage of justice, and then invite the appeal tribunal to intervene. That way, even if you fail at the trial court, you can always ask leave at the final appeal stage on a novel point of law, a point you had been at pains to establish. So now that you know these techniques, happy hunting, best of luck. And if you have any more points, send them to me. I'll put it all out with your name, and other lawyers and legal practitioners can benefit. Thank you very much and have a good day.